following program is not supercalifragilistic, whether it is the expialidocious variety or any other variety. The following program is also not espresso, sherbet, supposedly transphobic, or whatchamacallit, or any other completely made-up word. Good evening, everybody. Welcome to the following program. I am your host, Joe Neerman, a.k.a. Good Lawgic. Some of you may be brand new to this program. You may not know me. You may not know anything about me. You may be saying, who is this dude? Where did he get those cool glasses? You might be asking why I'm wearing 3 layers of clothing in the middle of summer. There's a lot of questions you may have. I can't really tell you everything about myself in a condensed enough time to introduce you to who Good Lawgic really is. However, I do feel fairly strongly, not compellingly, but fairly strongly, that we tell a lot about ourselves based on our sense of humor. Our sense of humor is indicative of who we are as people. And I found this video, which to me is just arguably the funniest thing ever. Arguably the funniest thing ever. I don't know why. And what I'll tell you is this will tell you a lot about me. And this is labeled, if Europeans made street food the same way Indians do. If Europeans made street food the same way Indians do. That's such a good touch. Throwing down white bread. Oh, this is so good. This is so good. Wrapping the bread. Everything with a nice flair. Nice flair to it. Using using an axe to chop up iceberg lettuce. Oh my god. There's so many layers. There's so many layers. So it's doing something. Random amounts of various ingredients. Just sprinkling. Lots of sprinkling, dousing. Let's take out the goop and pour it into a bucket. Here. Just a dose of gallons of water. Shake it around. Oh, that's the right amount. That's the right amount right there. Flip it. And now here we go. Some random hot plate. That wasn't even on a fire. Oh my god. This is so ice pick. Oh my god. And then just take a shovel and throw it into a newspaper. There you go. Oh my god. That is genius. I think it's genius. Oh, this is so good. So hopefully that tells you a little bit about me, who I am as a person. Now, because it's election season, before I get into the topic du jour, we have to do a couple of minutes just talking about developments in the race. And so here's one development that I'll share with you. There's a couple of clips I'll share with you that I just think are interesting, something you don't see every day. So this is what I'll call this segment, something you don't see every day.
My colleague Dana Bash reported that you, Senator John Tester, and Senator Sherrod Brown all said during that lunch that
this is Democrats meeting.
You don't think President Biden can win in 2024. Is that true?
Well, it's true that I said that. And I did say that behind closed doors. And
you
guys and others asked whether I had said it. And that is what I said. So I figured I should come here and say it publicly.
Why do you
I give him credit that he's not denying it.
think he can't win in November?
I just think this race is on a trajectory that is very worrisome if you care about the future of this country. Joe Biden was 9 points up at this time. The last time he was running, Hillary Clinton was 5 points up. This is the first time in more than 20 years that a Republican president has been up in this part of the campaign. Donald Trump is on track, I think, to win this election and maybe win it by a landslide and take.
I think it's going to be a landslide. That's what I'm thinking. Landslide.
Take with him the Senate and the House.
My colleague Dana Bash.
That's right. I want to see more than 300 electoral votes. I want to see more than 350 electoral votes. That's what I want to see. Landslide. Landslides. That was one clip I wanted to share with you. This clip just made me feel very, very flattered. Good. This clip made me feel very flattered that apparently folks like me are getting under the skin of Cori Bush. That's right. Folks like me.
Congresswoman, can you describe the temperature in the room?
Biden right now, the same right-wing influences that are trying to take me down are trying to take down President Biden. So
I want to take her down. Like, not in any, seriously, just politically. I definitely love to see an end to her career.
That's where my head is. But I'm listening to my colleagues and I'm listening to my constituents. At the end of the day, we got to beat back these right-wing influencers.
Congresswoman, can you describe?
Got to beat back the right-wing influencers. The right-wing that's right. We're coming for you. You and Biden. Those are two primary targets. Not really. Not really. Not really actually accurate. I mean, I definitely would love to see her out of office. That's for sure. That's for sure. Anyway, but a lot of people coming after Biden. Biden thinks things are going well, though. He thinks things are going well. In fact, things are going well everywhere for him. That's what even in Ukraine. Let's hear about his accomplishments in Ukraine, because I thought this was interesting. This is Biden talking about his accomplishments, how he's saving Ukraine.
Make no mistake, Russia is failing in this war.
Failing.
More than 2 years into Putin's war of choice, his losses are staggering.
Staggering.
More than 350,000 Russian troops dead or wounded.
350,000 dead and wounded. I don't know how you know how many wounded there are. So you're incorporating, how many dead bodies are there? That's what I want to know. How many dead bodies? How many dead Ukrainians? Because that's a better question. Like you're saying, like they're losing. Are there like 2 million dead Ukrainians to the 300,000 Russians? 300,000 dead and injured Russians? I just want to know. They won't tell us that number. We won't hear that number. How many dead Ukrainians? Every one of them, every single one on his ledger. Anyone who's dead in this war, it's because of him. It's because of him. Hundreds of thousands of dead people because of Joe Biden. Weirdly, that's not even the worst of his crimes.
Nearly 1 million Russians, many of them young people, have left Russia because they no longer see a future in Russia.
Actually, maybe they're coming here because we got an open border. I don't know. Maybe that's where they're going. I don't know. Maybe they're just walking across our border.
And key, remember, fellas and ladies, it's supposed to fall in 5 days. Remember? We're still standing 2.5 years later, and we'll continue to stand. Make no mistake.
I don't know what that means. It's still standing. Do they speak Russian there now? No one knows what's happening in the war there. Nobody knows. Nobody cares anymore what's happening in the war there. So, yeah. The problem that he's having is this. And I'm not gonna play the end of this video. I'm going to want to let you all, I'm gonna play the beginning of this video. Because this tells the tale as to why it is the Democrats are like, he can't win. He can't win. It's partially his cognitive decline. That's what woke them up. But here's why I think that we're going to be seeing 350. One of the key reasons why we're going to be seeing 350 electoral votes falling for Donald Trump.
I feel like I'm going to be sick. I just looked through my Walmart history, and I found this Walmart order from 2 years ago for the whole month worth of groceries. 45 items cost $126. A whole month of groceries just for me, basically.
So a month of groceries for him 2 years ago, 2.5 years ago, whenever, sometime in 2022, cost him $126 in 2022. $126.
But I did notice this reorder all button, and I wanted to see how much it would cost now.
So he's like, okay, I bought these items, 45 items that lasted me a month, for $126 from Walmart. Now I have an opportunity to just press reorder and buy the exact same stuff from Walmart. What do you guys think it's going to cost him to reorder in 2024? What do you think? I mean, he looks like, if you look at this guy, frankly, let's look at him. I look at him and I say, Biden voter, or at least 2020 Biden voter. Hey, this guy looks to me like your classic soy boy, Antifa, like let's go play Dungeons and Dragons and then just go bash some windows because Black Lives Matter or something like that. That's what he looks like to me. I could be wrong. Totally speculative. I have no idea who this individual is. But here he is, sick to his stomach. What do you guys think? Okay, so let's see some of your numbers here. Okay. You say, let me pull up some of these numbers here. I'm curious what you guys think. 350, 231, 400, 325, 400, 400, 345, 400, 240, 235. You say 3 times. That'd be like 375, 350. Okay, so you're all like in the 300 range, 2 to 300 range. Pretty much. Let me check over. I'm checking over on Rumble. So 350, 260, 327. Let me check with my. It's quiet over there by the diggers. Diggers are quiet. All right. All right. This is crazy. Let's check him out.
Now, this order of 45 items for 1 month would have cost $414.
400. Some of you got it like really, 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 really close. Some of you were really close. This is like the closest one I think that I see. 400.
That is 4 times more. How?
No, it's not. It's really not. It's really, really not.
The fuck? How? Like, what?
So yeah, it's really not. 4 times more would be $500, but it'd be over $500. But yeah, this is a really good guess, Barnabas. That was the closest guess that I saw so far. Anyway, it's 3.5 times old because it's old. Yeah. Now it's by the time we posted it, it's 450. I don't know. Anyway, but don't think that like the press. What we're seeing here is that the press is starting to zero in. They're starting to zero in. And I thought that this, when I talk about things you don't see every day, check out this interview, because this is a 3-minute interview, which just okay.
You noticed anything that gives you a red flag as a doctor?
Oh yeah, I see him 20.
He's a neurological specialist, this guy, supposedly, and supposedly a Democrat. Oh, let me grab these couple super chats real fast. If Biden stays in, he'll win. The Dems will steal election like they did in 2020, create enough fake votes to overcome Trump lead. They know the state legislatures and courts won't stop them. Yeah, okay. I think they're going to start losing states that they're not even like thinking about. So you're getting under Cory Bush's skin for something other than being a zoo. Being a zoo? I know what you're saying. Citrus? Apparently I am. Hi, Corey.
Times a day in clinic. I mean, it's ironic because he has just such classic features of neurodegeneration. I mean, word finding difficulties, and that's not, oh, I couldn't find the word. That's from degeneration of the word retrieval area.
He's also overcome stuttering, though. Could that be part of that too?
No, this is not a palatal issue or a speech discrepancy, which is very different from a lemino dysfunction, actual word retrieval, where you pick a similar question.
See, he's using terms that make him sound like he's an expert, like lemino something. I don't know. I wouldn't come up with that.
Or talk around the issue, plus the rigidity, monotone voice.
Wait, go back to that, the rigidity. What do you mean?
Rigidity, loss of arm swing, standing up lordotically. You notice when he turns, it's kind of end block turning. It's not a quick turn. So that's one of the hallmarks of Parkinson's is rigidity and bradykinesia, slow movement. And he has that hallmark, especially with the low voice that said was a cold, hypophonia. A small monotone voice like this over time is a hallmark of Parkinsonism. I could have diagnosed him from across the mall.
Here are some of the symptoms from Parkinson's. We just had him up there on the screen. If you put him back. What about the movement? Some people have pointed out the way he walks. Sometimes it's not very.
Stage 4. That's what we're just going to call everything about this administration. This entire administration should just be referred to as the Stage 4 administration. World War III, Stage 4. Parkinson's, Stage 4. Everything here is Stage 4.
Fast, small steps. Is that something that is common in people who are battling a disease like Parkinson's?
Yeah, it's a hallmark. Shuffling gait, we call that, so little steps. Loss of arm swing from the rigidity. When we walk, we have a nice cadence. You notice he doesn't really swing his arms. And end block turning, meaning he kind of pivots around his foot. If you said, hey, President Biden, he wouldn't go like this. Yeah.
But I also know, and tell me if I'm wrong here, it's very hard to diagnose Parkinson's, isn't it? It's not simple. I mean, I've heard that it can be.
It's one of the easier movement disorders to diagnose, actually.
Right,
but it's so clinic. There's very little others. And I'm a Democrat. I always say about this.
Right.
It's just like this guy is not a hard case.
But I've had relatives who have gone through neurological issues, and I've heard that sometimes Parkinson's is not very easy to nail. You have to take a lot of tests.
It's early on. If you're just presented with like hallucinations, that could be a variety of things, or just the cognitive problems. That could be Alzheimer's versus Parkinsonism, and that becomes a little nebulous. But once you start manifesting the hallmark motor symptoms,
right?
Slow movement, rigidity, mass facies, hypophonia. I mean, if a med student did not pick Parkinson's on the test, they'd be remediated.
So let me ask you, you're a Democrat, you're a doctor. You sound like you're frustrated with what the White House is saying.
Yeah.
Why?
Well, because, I'm an American before everything. And I look at it and say, when I used to see Russia, Soviet Union, North Korea, when they just make outrageous things, like when North Korea can't keep the lights on and they say, oh, it was some faulty power thing. I kind of hate that kind of stuff. They had 4 years. My own party had 4 years to find, this was a wreck in slow motion. And they had 4 years to find out of 350 Americans, one person that could take the place. And here we are the day before school trying to do the homework and replace a guy who's got a neurodegenerative disease.
Dr. Pitt.
Well, there you go. Frustrated Dr. Democrat. But surely Karine Jean-Pierre, KJP, is about to set us straight, right? I mean, obviously, she's going to set it straight. There's all these signs that you could diagnose him from across the mall. Surely she's going to set it straight. Let's hear from her today.
He's sharpest before 8 p.m.
He's sharpest. This is him. This is Peter Doocy, bane of the Biden administration, picking up on where KJP mentioned that he's sharpest before 8 p.m.
So, say that the Pentagon at some point picks up an incoming nuke. It's 11 p.m. Who do you call? The First Lady?
I threw this out yesterday. They say he sunsets during the day. He's sunsetting from the time he wakes up. Almost like the batteries like running out on one of my vapes where I'm like, it's coming. It's coming. So he sunsets throughout the day. Yeah. So what does happen at 11 o'clock at night? What happens there?
Are you guys just not, since February, testing President Biden for Parkinson's or for dementia? Because if he gets a bad result, it's all over that day.
All right. Thanks, everybody.
Whoa! I'm out of here. I am out of here. I am not answering your questions. But that's an interesting question from Peter Doocy. Are you not diagnosing him because you're afraid that will end his political career if you actually got anyone to sort of spend 3 minutes testing him? Is that why? Is that why? That's not why. He's been tested. They know. They're giving him medications to stop the tremors. They know. They're just lying to you. They're lying to everybody. That's what it is. Still, I think he should stay in the race. Totally stay in the race. Go, Joe. You can do it. You can do it. You can do it. It's so easy. And finally, let's take a look at Jake Tapper. We're going to close out with Jake Tapper here because Jake Tapper, even he's asking questions. Here's Jake Tapper asking questions. That's right. The guy who was hosting the debate which exposed Joe Biden.
In reality, 72% of voters say that they believe President Biden is too old. That's according to CNN's most recent polling. Voters have been saying this for quite a long time. The reality is that the Democratic elites are mostly late to acknowledge these age and ability issues compared to the rest of the public.
Late to acknowledge? Everyone knew it. Why are all these elites late to the party to acknowledge it? Everyone's known it.
The elites have been forced to reckon with it after the debate just 11 days ago.
Look at my career. I've not had many of those nights. It was a terrible night, and I really regret it happened. But the fact of the matter is, how can you assure you're going to be on faith that can intervene on your way to go to, work tomorrow? Age wasn't, the idea I'm too old.
The fact of the matter is, how can you assure you're going to be out on your way to go, work tomorrow? Age wasn't, the idea that I'm too old. Keep in mind, that soundbite is supposed to be reassuring to those Democratic supporters who have gone wobbly. Many Democratic officials with whom I've spoken are worried that President Biden and his family and his inner circle appear to be in complete denial, not just about whatever might be wrong with him, but the state of his candidacy right now.
So he's angry at the elites. Why didn't you come forward beforehand? Why? What happened here? What happened? I don't understand. Why is it that we're only hearing about this now? Everyone knows. Well, maybe it's because of you, Jake. This was Jake, what, a year and a half ago? 2 years ago?
Every time he comes on stage or they turn to him, I'm like, Joe, can you get it out? Let's get the words out, Joe. You kind of feel bad for him.
How do you think it makes little kids with stutters feel when they see you make a comment like that?
Stutters?
First and foremost, I had no idea that Joe Biden ever suffered from a stutter. I think what we see on stage with Joe Biden, Jake, is very clearly a cognitive decline.
Okay.
That's what I'm referring to. It makes me uncomfortable
You have
to watch somebody on stage search for
it's so amazing. It's so amazing to me that
try and figure out an answer.
a cognitive
But
decline.
when you're trying to tell me that what I was suggesting was
I
a
think that you
stuttering,
were mocking his stutter.
Yeah,
I think you were mocking his stutter, and I think you have absolutely no standing to diagnose somebody's cognitive decline.
No standing to diagnose cognitive decline.
But I would think that somebody in the Trump family would be more sensitive to people who do not have medical licenses diagnosing politicians from afar. Plenty of people have diagnosed your father from afar.
You diagnosed Biden. What the hell are you talking about? This guy is such a friggin' hypocrite.
And I'm sure it offends you, your father-in-law from afar. I'm sure it offends you. You don't have any standing to say.
No standing.
Saying,
you just
Jake,
talked about a cognitive decline.
That Joe Biden
I have
is
one last
struggling
question for you, Laura. You can't
times on stage, and it's very concerning to a lot of people that this could be the leader of
Lara Trump tried telling you, and you sat there gaslighting as you always did.
the free world.
Okay.
That is all I'm saying. I genuinely feel
Laura
sorry
Trump.
for Joe Biden.
I appreciate it. I'm sure.
Look at this clown. What an utter clown. Then he comes out now. He's like, why didn't people say anything? Why didn't they say anything? Because folks like you were carrying water. For the interview of the doctor, they say you can tell the truth, not carry the water. I guess so. Yeah, well, he's an excellent. Jake Tapper is an expert at carrying the water. Victory lap I call Parkinson's features back 1 year ago on Gouveia channel. Brady kinesia, masked faces, festinating gait, hypophonia. See, that's what the New York renal doctor. He's a renal doctor. That's not Parkinson's, but still, he called it. There you go. There you go. So things are a struggle. And finally, the guy who had an interview with Biden most recently, George Stephanopoulos, busted by a hidden camera. It's a little hard to make out the audio on this, so I just want to warn you to let me see if I can do something to pump up the volume a little bit, because the audio here, the guy was trying to be discreet, and it's a little hard to hear. So we're going to turn up the volume here so you can hear George Stephanopoulos.
Hey, Susan, hey, how you doing? Good. What do you think? Do you think Biden should step down? You talked to him more than anybody else have lately, and you could be honest. You don't think he can serve 4 more years? All right, that's an answer.
I don't think he can serve 4 more years. George Stephanopoulos. Interesting. He's wrong. Biden, go, Joe. Go, Joe. Go. Go, Joe. Go. You got this. All right. So that's a little round the world with respect to the election season. I want to give you all an update with respect to the Baldwin trial. Today, 16 jurors were seated, 12 and 4. They have 4 alternates that they brought in for this trial. All 16 of them seated tomorrow morning at 10:30. Yours truly, 10:30 Eastern time, 8:30 Mountain time. Yours truly will be streaming this trial. I urge you, come back here tomorrow morning. Set your alarms. You're not going to want to miss anything. I am going to be streaming this trial tomorrow morning, 10:30, right here on this channel. So I'm urging you all to join me. The link has not yet been set up, but I plan on setting it up shortly after I wrap up tonight's stream. And I will be streaming it to Rumble. I'll be streaming it to YouTube and through locals. I'm not going to be streaming it to X. If you are watching me on X, which apparently a number of you do, I'm urging you to sign up on either YouTube or Rumble or locals and watch me through there. I am not going to be streaming this trial through X. So I'm just giving you all that heads up. If you are an X viewer, I urge you, come on over. Finally, jump in. The water's fine. Maybe you can become one of my subs. I'm bleeding subs again. Earlier today, I was at 99,380. YouTube. Bastards. You bastards. Yeah. Verbissene Antisemiten. So I urge you, come on over, sign on up. You can still be one of the first 100,000. That's probably going to change very shortly. I'm going to cross that threshold and be like, oh, damn it. I could have said I was one of the first 100K. So window opportunity is closing. But today, prior to voir dire, where they were selecting the jury, there were some motions and applications brought by both sides, one of which, and the result of one of which actually caused some real damage, potential damage to the prosecutor's case. I just want to bring this to your attention. And specifically, I'm referring to this ruling by the judge earlier today. Judge decides Alec Baldwin's role as co-producer was not relevant to trial over the fatal 2021 set shooting. Alec Baldwin's role as a producer of the Western film Rust is not relevant to the involuntary manslaughter trial over a fatal shooting on set, a New Mexico judge decided Monday. The move is a major setback for prosecutors just as trial is about to begin. They had planned to present evidence that showed how Baldwin bore a special responsibility as co-producer. It is a little ponderous because, well, let's read a little further. Well beyond that of the actor holding the gun, for the dangerous environment that led to the deadly shooting of cinematographer Helena Hutchins during a rehearsal. And here's the interesting thing. The judge says, quote, I'm having real difficulty with the state's position that they want to show that as a producer, he didn't follow guidelines, and therefore, as an actor, Mr. Baldwin did all of these things wrong that results in the death of Miss Hutchins because as a producer, he allowed these things to happen, Judge Mary Marlowe Summers said. Quote, I'm denying evidence of his status as a producer. What? I'm having a difficulty with the state's position that he failed to do things as a producer that put him in a position where he's more likely to have an accident and kill someone as an actor. Okay. Not sure why. I'm not sure why that would not be relevant. I don't even understand this. It's a little confusing to me. That he didn't follow guidelines, and therefore, as an actor, Mr. Baldwin did all of these things wrong that resulted in the death of Miss Hutchins, because as a producer, he allowed these things to happen. Like having live ammunition on the set, or failing to take care to properly vet out who's handling stuff or be on top of the situation. Look, if you want to tell me that you accept as a matter of, that factually a jury were to find that was not part of his bucket of things he was supposed to take care of as producer. Because there are different producers on the set of a movie, and some of them have different roles, much as in any corporation that you're running things. So one person might be the money guy, the other guy might be in marketing, another person might be as far as like the overarching plan, or manager on site to see day-to-day stuff. You can have different roles, and perhaps amongst producers that is the case. We've seen in various interviews where Alec Baldwin claimed that that's not the sort of type of producer that he was. He was supposed to oversee talent. And that was the nature of his role as producer, which may be true. In which case, if it is true, you would think, okay, so if he's not managing day-to-day operations, he's just there to sort of make sure that they have a solid person to play a particular role in the movie. At that point, once you reach that factual conclusion, I can understand that his role as a producer has no impact on ensuring the day-to-day operations. Right? I mean, that would make sense. But right now, there's no findings of fact as far as I'm aware. So it's a little strange that she's sort of jumping into his corner and saying, oh, okay, the fact that you're a producer is not admissible because it's not relevant. It's a big win for Baldwin. Not going to kid you. Special Prosecutor Erlinda Ocampo Johnson argued unsuccessfully that Baldwin was keenly aware of his safety obligations as a producer in an attempt to bolster an alternative theory of guilt beyond negligent use of a firearm. The prosecution has tried to link Baldwin's behavior on set to a total disregard or indifference for the safety of others. So you see this, and this could have been why. There's two different ways you can look at the same fact, and this is something that is probably going to come up frequently during the course of the Baldwin trial. Your negligence can take different forms, right? So you can have negligence with respect to not taking proper steps to ensure that the gun is not loaded, or negligence with respect to the direction you're aiming the gun, or negligence with respect to allowing live bullets onto the set, or negligence with respect to not following basic standard protocols that are followed on most movie sets. Now, if you want to tell me that the judge is saying, I don't want him being thrown in jail for this element alone of allowing bullets on set. A, I think Hannah Gutierrez, the armorer, would have all sorts of questions about that because she's in jail for that. B, I mean, I guess I can. That doesn't mean you should keep out his role as producer altogether, because the role as producer would affect the knowledge he has. Forget about him being culpable. It's his fault that the bullets are there. It's his fault that the gun, that there's a live round inside the gun. What about the fact that he should have had added knowledge that another actor who's not a producer would not have had? And with that added knowledge of the dangers of the situation, perhaps he should have taken more care than if a different actor was holding that gun and it went off. You see what I'm saying? In other words, not that he should be found guilty. That's your fault that there was a live round in there because you're a producer. And I think perhaps the state, and I didn't get to see live arguments, but perhaps the state made an error, because it seems as if this alternate theory that the state wants to present may have ended up shooting themselves in the foot. Because if they want to say, we want to have him held guilty, either as the gun pull, as the trigger puller, or because of his negligence as producer, so that his negligence as producer would mean even if someone else had pulled the trigger, his negligence as producer would be a reason to have him convicted. Make it like separate and apart from the fact that he pulled the trigger. And that would be a reason to have him be convicted. And it's possible that the prosecution tried going for that. And they said, we want to bring in here that he's a producer so they can convict him either for pulling the trigger or for creating a scenario, much as Hannah Gutierrez was found culpable for creating a scenario which led to Helena Hutchins' death. That would be a big reach by the prosecutor, because he's not the primary person overseeing it. There's a bunch of producers, and that would be a bit of a reach. And perhaps they didn't make that reach. Like I said, I didn't get to see oral arguments on this. If that is the reach they made, that's a terrible mistake, because his role as producer can have several different impacts as to how it would come into this case in a way that could be meaningful. One of them would be, just for that role alone, he's guilty. Judge is not going to accept that, clearly. She doesn't want to accept that he would have guilt as for his role as producer. And it's possible, this is sort of like a gamble that litigators take frequently, where they're like, how do I want to present this in a way that the judge is going to accept it? I'd rather have it, as broad and far reaching as possible, and have his role as executive producer come in a multitude of different ways, and have the judge recognize that as potential theory. Because if it's recognized as a potential theory, in that case, in theory, in that case, when it comes time for jury charges at the end of this whole thing, they could hold him liable purely on the basis of his role as producer, irrespective of him being a shooter. Now, the reason I think in this particular case, if that is what the state did, I'm not saying that is what they did, but if that is what they did, I think that's a terrible mistake. I think that would be a terrible mistake. I'm reading between the lines here based on this decision. that is what the state tried doing. I could be wrong, but I'm simply saying that's what I'm reading between the lines. And if my read between the lines is accurate, I think that was likely a terrible mistake by the state. The reason it's a mistake by the state is because you're not going to have any disagreement that he was the shooter. Everyone knows he was the shooter. There's no dispute. No, I wasn't the one holding the gun. It was Larry who was holding the gun. It was Tommy who was holding the gun. Everyone knows he's the one who pulled the trigger ultimately. He was the last line of defense that could have saved Helena Hutchins' life. So why would you try getting him caught up on some theory that you're guilty because you're the producer? If I was arguing this to the judge, and I'm not saying I would have won if I was arguing this to the judge, but if I was arguing to the judge on behalf of the state, I would say, look, because he's producer, he has added knowledge that any other actor on that set who's not a producer would not have had. That added knowledge should put an added amount of precaution into his activity. And it's fair for a jury to say that you were that much more reckless because of your position as producer should have made you more alert. We all understand that if you're driving down a hill on a mountain, right? On a winding road on a mountain, we all understand you're going to have a certain level of precaution. Well, if that mountain is covered and the roads are covered in snow, your added levels of precaution are obviously far, far greater. Far, far greater. Visibility is down, slippage is more increased. Because of those reasons, you have a duty to be that much more cautious. So perhaps whatever level of care you would display on a clear, dry day, that level is insufficient given the conditions that you are aware of, that there's a whiteout and that you're driving down this road. So your normal operating procedure for a clear day is not, that would be something that people would be considered to be reckless and dangerous if in fact it's a whiteout, because you're aware it's a whiteout. And my point is that the state should have said he had added levels of awareness of the danger of the situation, that this was like the snowy road because of all the safety issues that were happening on set. And he had that knowledge because he was an executive producer. And because of that, he had a duty to display the same level of care a driver would have driving down that road in snow, rather than another actor who might not have been aware of the terribly dangerous conditions, the reckless conditions, and might have thought it's a clear day. It's not a snowy day. It's a clear day on set. It's not a dangerous day on set because of all these different union issues and arguments and things happening with the armor, and might not know about guns going off with live ammunition multiple times in the past, but that he, as executive producer, has knowledge, and that knowledge should have added to the level of security and care he should have displayed on the day in question. That's how I would have argued this to the judge as a basis to get in his role as executive producer, not to say, well, because he's executive producer and she ended up dead, he's now responsible. Even if he wasn't the shooter. Why would you make it that way when there's no argument that he pulled the trigger? So if they did it that way, I think, I'm not saying they did, but if they did argue it that way, it was a terrible mistake. In the courtroom Monday, Baldwin sat between lead attorneys Luke Nikes and Alex Spiro. He appeared to listen intently, taking occasional notes on a yellow legal pad and handing written messages to attorney. Baldwin wore glasses and close crop hair. Trial starts Tuesday with jury selection and is scheduled to last 10 days. So I'll tell you, today was Tuesday, but we got real trial starting tomorrow. Sorry about that. Okay. Oh, let me go a little further. Just go a little more. Last week, the judge cleared the way for crucial firearms experts for the prosecution to testify about Baldwin's handling the revolver and whether the gun was functioning properly prior to the fatal shooting. Monday, the judge decided prosecutors to exclude at trial summary findings from a state workplace safety investigation that places much of the blame on Assistant Director Dave Halls. Halls has pleaded no contest to negligent use of a firearm and may be called to testify at Baldwin's trial. So he could be a potential hazard for Alec Baldwin. Prosecutors say the workplace safety investigation was incomplete, unreliable, and glossed over Baldwin's responsibilities in the fatal shooting. Russ Movie Productions paid a $100,000 fine to resolve violations of state safety regulations that were characterized as serious but not willful under a 2023 settlement agreement. Several witnesses to the workplace safety investigation are likely to be called to testify at Baldwin's trial. Prosecutors also be able to present at trial graphic images of Hutchins' injuries from an autopsy report over objections from the defense, as well as police lapel camera video of the immediate aftermath at the shooting as medics arrived on set to treat the wounded Hutchins and Souza. We're going to get to see all of that. We will likely be able to see all of that at trial. Hopefully they share that on screen with us. Baldwin is charged with a single felony count of involuntary manslaughter, punishable by up to 18 months in prison if he's convicted. Hannah Gutierrez-Reed, the armor on set, was convicted. Hutchins then sentenced to 18 months in prison. She's appealing. All right. I need to go further. I think we got this right. Yeah, we're not going to read the rest of this. Then we're good. So that all starts tomorrow morning at 10:30. I urge you to join me right here on this channel, Good Lawgic, and have a good time. You can watch me on YouTube. You can watch me on Rumble. You can watch me on Locals at goodlogic.locals.com. I was chastised that I haven't played this guy in a while. I'll tell you all, sub on up, run on up the bookcases, and just hit the sub. Hit it. Check it, Bavaka shop. Hey, hit it. So there you go. It's been hit. So now, I don't know why you haven't subbed. Why would any of you not be subbed right now? It doesn't even make any sense. No one understands any of this. All right. If he has Parkinson's, will this limit ability to sniff little girls' hair? Come on, man. Again, he just has to move very robotically. But I don't think it affects his sense of smell. So little girls still be wary. Still be wary. Doolin Dalton. I question why any live rounds would be allowed anywhere on the 7 movie like this ever. Yeah. Yeah. Good question. And yes, he should have checked no matter who told him it was safe. Screw that. Yep. Totally agree with you on that. I'm never here on time. I normally watch in double speed a couple hours later the next day, so it's kind of weird hearing your normal voice. Hey, Kenny. Thank you, Nixie. Oh, we had a good time. Oh, I appreciate you sending the troopers out. Great to see you on here. Okay, fine. I just wanted you to feel at home. So, there you go. If it was self-expunged scene, I bet you he'd check the gun. You know he would. You know he would have. No one wants to. What's that guy's name? John Errol Hexum? Is that it? John Errol Hexum. You gotta be old to remember this. I think that's his name. John Errol Hexum. In the 1980s, there was this upcoming TV star. Pretty sure his name was John Eric Hexum. Now I gotta Google and see if I got that right. I know John is spelled with no H. John Eric. Hey, I got it right. This guy. This guy had everything going on for his life. Everything. He was on a TV series, I think, called Paper Dolls. Heartthrob. Everyone loved him. And just he decided to, it was in 1985 where he basically decided that he's going to show up for some girls and play Russian roulette with blanks and aim the gun at his own temple. And apparently some sort of, I don't know if it was, he didn't realize that if you put it against your head that he put it against your head that I don't know the way it works with the suction or whatever, but basically he ended up self-inflicting, self-deleting. It's a real tragedy. I remember him from Voyager. That's what I remember him from. This was a great show, Voyager. Time Travelers, Voyager. Voyager from the Unknown. Great show. Let's check it out. Anyway, yeah, so no one wants to John Eric. Everyone in the acting industry, everyone in Hollywood is very aware of the John Eric Hexum story, the John Eric Hexum tragedy. So, yeah, I agree with you. He definitely, if it was a self-expunged scene, he definitely would check that out. Not sure if you saw my DM. It's about Gibson Go to help cover some expenses my wife recovers. I don't want to share unless you're okay with it, though. Yeah, that's fine. You can share it in the chat. That's totally fine. You can share in the chat. I did see it. I wasn't sure what to say, only because I did a whole pitch yesterday for another digger, and I was like, I can't do this like every day. So I was like, but I don't want to say no. So I was just sort of like, I don't want to go through the whole pitch. But if you want to share links, by all means, feel free. You can share links. That's totally cool. Like if you had asked me like a week later, I'd be like, yeah, okay. That's probably would have happened. That's probably what would have happened. But the day after, I was like, I can't do this every day. So, Doolin Dalton, drop him. 10 good Lawgic memberships. 10, count them. 10 good Lawgic memberships. I don't have. Did I miss it? Oh, I hope I didn't. 10, count them. 10. I really hope I didn't miss it. Oh, I didn't. All right. Who do you bring on board? Endless 013, a pear tree. Threat, the art of my art. The art of my art. The art of my art. All right. Justin Haas. Old Drill Sergeant. Tigger 07. Just mentioning you. Kool-Aid 2008. Cronite. Moo Gaming. Grateful Ted 12. All of you gifted memberships courtesy of Doolin Dalton. Welcome to the following. The following is just that you're now a follower. You are now a follower. You can't get away from being a follower. You are now a follower. But rest assured, okay, even though you're labeled a follower, and I know for some of you this might be a very new experience. I mean, you might be a little confused. I'm telling you now. The following is really just about community, unity, and leadership training so we can use those factors for our own personal growth. But it is in no way, shape, or form a cult type of cult. It's not even remotely a cult type of cult. So, yeah, I welcome you all. I thank you, Doolin Dalton, for bringing these people on board. Thank you, because we need a greater community, a stronger community, a powerful community. Now we know the story of John Eric Hexum. But what tonight's show is ultimately about, what you're all here for. I know what you're here for. I know what you want. You're here for it because you want to know about Judge Glanville, right? That's probably what you're here for. Well, either that or because you want to hang out with your friends. Lord knows that that's certainly a possibility. All right. Those of you who are not familiar with the story of Judge Glanville, I am not going to read through the main part of this application. And this application was filed yesterday by Brian Steele. Today by Brian Steele. I'm not going to read through the main part of it. The main part of it primarily is a review of facts that most of you who've been following the YSL case are aware of. YSL, Young Thug, RICO charges down in Fulton County. Most of you are aware of the scenario. I will give you a 30-second overview. And the reason I'm sharing with you this 30-second overview is because my objective is to save you from 30 pages of detailed overview. 30 pages of detailed overview. I'm going to read through just a couple of pages from this instead of 30 pages and jump down to the really new information, which comes later, which comes down below. Now, what's the story? Well, in Fulton County, there are charges that are brought against 6 defendants, one of them being Young Thug, who are all members purportedly members of a gang, and there are RICO charges that are they're facing criminal charges for right now. And they've been involved in this trial for ever. And this trial is expected to run through the balance of the year. On or about June 10th, there was a situation with Judge Glanville, who's overseeing this case. What was the situation? Well, there was a witness by the nickname of Little Woody. His real name is Kenneth Copeland, who was associated with this gang, and he did not want to testify. He was granted immunity by Assistant District Attorneys Hilton and Love. They said, we're giving you immunity, that we can't prosecute you, so now you can no longer plead the fifth. On Friday, June 7th, he came into court and said, I'm pleading the fifth. They said, you're not allowed to plead the fifth. Once we give you immunity, you're not allowed to plead the fifth. He said, I'm pleading the fifth. They said, you're going to spend a weekend in jail because you need to testify, and your refusal to testify when there's no exposure to you is not proper. On Monday, June 10th, when trial was supposed to start at 8:30 in the morning, instead of everyone coming into the courtroom, defense counsel were all there by like 9 o'clock or so. And they're sitting there and waiting and twiddling their thumbs. And the reason they were waiting is because Judge Glanville was in chambers talking with Kenneth Copeland, Little Woody's attorney. Her name is Kayla Bumpus. And with a couple of assistant district attorneys in front of a court reporter. And they were talking about the nature of testimony and what steps they were taking and why it is that Kenneth Copeland's other attorney was not there and that Kayla Bumpus was filling in for him. And they ended up bringing the witness who had already been sworn in on Friday, ended up bringing him into judge's chambers. At which point in time, the judge and assistant district attorneys began putting immense pressure on him, threatening him that if he were not to testify, he's going to spend the rest of this trial in a cell. Moreover, that they would keep him there until they finished prosecuting an additional, 20 people based on his refusal to testify. The judge was showing him the law on this. And the reason this is called an ex parte meeting. It's very, very inappropriate to conduct an ex parte meeting. Judge is never allowed to do that, to have an ex parte, because none of the defense counsel were apprised of this entire situation. Quite the contrary, they were specifically kept in the dark. The only people there was assistant district attorneys and the witnesses' lawyer, but none of the defendants' lawyers. There's a whole host of those lawyers. None of them were told anything. We later learned that Kayla Bumpus and the Copeland's attorney, Kayla Bumpus, is the one who exposed this entire thing and gave some significant detail about what happened there. But that afternoon, when they came back into court, Brian Steele, counsel for one of the defendants, got up there and said, what the hell is happening here? We heard there was this whole meeting here, and we should have been told about this, and that's not allowed to happen. It's completely inappropriate. There's no reason to have an ex parte meeting with a witness, especially when you consider the fact that what they had heard correctly based on the transcript was that he was being threatened. Not only was he being threatened, he was also being told by the assistant district attorney when he said, you want to force me to testify? Fine, I'll get up there and I will lie. And they said, if you lie, we're not going to prosecute you. So now you have the judge and prosecuting attorneys sitting together telling them you must testify, and if you lie, that's okay. We're not going to come after you. Plus, then he says, I'll say I'm the one who committed the whole pew pew. And they said, well, if you do that, then we will come after you for perjury. So if he had given testimony that would help exonerate these defendants, then they're going to prosecute him for perjury. Anything else, like saying that they're the ones who did it and lying about that, they won't prosecute him. This is just outrageous. And sitting there with the judge, the reason the assistant district attorneys could have had this conference with him privately without doing it in front of the judge. The reason they did it in front of the judge was to put added pressure, like they're working in cahoots with the judge. This is an egregious violation. And once you have this ex parte meeting where one side is not there, the judge is duty bound to apprise the other side, hey, we had an ex parte meeting, and to basically explain the nature and why you had the meeting and call to their attention. Well, rather than owning up to it, instead of owning up to it, Judge Glanville turned around and said, how do you know this? Who told you this? I want to know. And the attorney was like, I'm not telling you who told me. That's attorney work product. It's privilege. I don't have to tell you this. Judge's like, you're going to tell me. No, I'm not telling you. I'm going to hold you in contempt if you don't tell me who did it. He suspected it was Caleb Bumpus at the time. Everyone suspected it was, but he was not going to give her up. He was not going to sell her out. And he said, I don't have to. And I don't know why you're asking me these questions. This isn't privileged information. This is information that's not merely privileged, not unprivileged, but information by law you're obligated to tell me about yourself, Judge, and you didn't. And this entire meeting was inappropriate. And he wants the judge removed. Because after this whole thing, so the judge said, I'm throwing you in jail for contempt. Later overturned by the Supreme Court of Georgia, saying that's not happening. But he issued him to spend 10 weekends in jail. It was a whole big brouhaha. It was craziness that was happening. Craziness. Madness, I say. But with balls of steel, attorney Brian Steele said, I'm not giving it up. They brought a motion forcing Judge Glanville to recuse himself. Today he filed, at the time, he kept saying, I want the transcript. Judge says, I'm not giving you the transcript. After the Supreme Court came down on the judge and said, you're not doing this right. You haven't been doing this right. So he gave up the transcript. Transcript doesn't look very good for him. It looks pretty bad. So he had filed a motion compelling him to recuse himself. The motion, part of the whole issue here is, in the motion to recuse himself, what Steele was arguing, as were many of his co-counsel, he was arguing that Judge Glanville himself has no power, authority, jurisdiction to decide this motion. It has to be decided by a third-party judge. Now, I should mention to you something that we haven't discussed yet on this channel, is that there's another judge who is associated with this case. If you look at the docket for Georgia's criminal court, it says it's assigned to Judge Krause. So, and that she's the one who's overseeing this. And he wants both of them recused, as we're about to see right here and now. First, let me get to this. Jenny L. Hiya. Have a pleasant night. Like and sub, good people. You're so awesome, Jenny. Thank you so much. Member for 23 months, Christina Huff. God bless you, woman. God bless you. Fence broke, goats gone, nothing for the offering. I don't know. Fence broke, goats gone, nothing for the offering. That took me a second. That's pretty funny. When he was live with lead attorney, it was wild. I did see that. Joe, check out footnote 3 on the first page. I will. So, I don't want to go through the main part of the supplement. It's sort of, but this supplement that's introduced by Brian Steele is, now that the transcript has come out, now that the transcript has become some information and evidence, that they want to use this transcript to supplement their initial motion to have him recused and to force the recusal of Judge Glanville. The ultimate goal is recuse him and dismiss this entire case based on the gross misconduct of the judge working together with the district attorney. And it's unfair prejudice and double jeopardy to the defendants for them to have to sit through this yet again. So, supplement to motion to recuse. Comes now Mr. Jeffrey Williams, his client to Brian Steele, by and through undersigned counsel, and hereby timely files this supplement's motion to recuse Judge Glanville in the above referenced case and support his motion. Mr. Williams shows as follows. So it's supplement motion to recuse Judge Glanville, and there's 3 footnotes that they have on this. What are the 3 footnotes? Because this is kind of interesting. This is kind of interesting. This motion applies to lawyers Love and Hilton. These are those assistant district attorneys who sat in a conference with Judge Glanville. This motion applies to lawyers Love and Hilton in addition to Judge Glanville, as all 3 are material witnesses in the case at bar, and all will be called by Mr. Williams during trial to show judicial and prosecutorial misconduct. That's right. We are going to call the judge to the stand. If this case moves forward, we are going to want to call the judge to the stand to show the prosecutorial misconduct. Wow. We're going to put him under examination. We're going to put this district attorney under examination. What utter humiliation. This is utter humiliation that the defense is going to call the judge as a witness. Utter humiliation. Can you imagine? Imagine for a second here. You are one of the poor, betrodden jurors on this case. You've been sitting on this case for what? I think since October of 2023. For 7, 8, 9 months. Every day you come into Fulton County Superior Court, you check in at whatever time the judge tells you to be there, and you spend your entire day sitting in that courtroom. And what you've seen day after day is Judge Glanville up there and assistant district attorneys Hilton and Love doing their thing, calling their witnesses in this cockamamie, convoluted case, presenting testimony day after day after day, and jury instructions and objections and cross-examination for months. I mean, it's just going on and on and on. It's just going on and on. It's just happening day after day. And suddenly one day, you wake up and the judge ain't there no more. He's not the judge. There's a new judge that's been assigned to this case. And the assistant district attorneys, whose outfits by now you probably know everything in their wardrobe because they've gone through them all, right? I mean, no one's got 70 different outfits to wear to court. I mean, you literally know everything about these people. From a professional standpoint, you know the cadence of their voice, you know the type of questions that they ask, you know everything about them because you've been seeing them day after day after day. And those attorneys are gone. New attorneys, new district attorneys. You never see these folks anymore. You never see Judge Glanville. You never see ADA Love. You never see ADL Hilton. They're gone. New judge, new district attorneys. Case goes on for several more months, and then finally the prosecution rests, and defense starts calling their witnesses. And who's one of the first witnesses they call? Defense calls Judge Alec Baldwin. Defense calls Assistant District Attorney Love. Defense calls Assistant District, and you just hear about all the shenanigans that happened in that back room. And then you told him this because you wanted him to testify, and you promised him you wouldn't, that if he could lie and you wouldn't even go after him, that you wouldn't even prosecute him unless he accepted blame for the pew himself, in which case then you were going to come after him. But you were totally fine if he said, I'll lie, implying if he would lie about my client committing these awful crimes, you were totally fine with that. You told him, you go ahead, lie as much as you want. I'll never prosecute you. But if he said anything to exonerate my client, in that case, then you were gonna accept that. Then you were gonna threaten him with prosecution. You said you gotta stand up there. You can say whatever lies you want, just nothing that's gonna help the defense. Then you threaten him that you're gonna throw him in prison and make him stay there for potentially years. Years. Judge, you signed off on this. These are all questions that they would have to face. The humiliation for Judge Glanville, the humiliation for the district attorney's office. Such utter humiliation. So much so, I dare say that if this recusal happens, district attorney, even if the court doesn't remove this case, district attorney might just drop the case altogether. Say we're out here. Frankly, they probably should have done that a while ago. So, first they want to get rid of lawyers Love and Hilton. Now, this motion also totally moves to accuse the Honorable Judge Krause, based upon the fact that she sits on the Fulton County Superior Court bench with Judge Glanville. So she's associated with him, and that in April 2024, Judge Glanville contributed $2,000 to Honorable Judge Krause's reelection campaign. Yeah, they're in bed with each other financially. No one's making accusations about, but they're politically in bed with each other. Also in April 2024, the Honorable Judge Krause donated $500 to Judge Glanville's reelection campaign. They're just like coughing up money to each other. Mr. Williams' trial has been ongoing since January 4th and therefore includes April 2024. So while this case is going on, these two judges are donating to each other. So she's not any good to be a part of this and step into the void. She's coughing up to keep him in office, and he's coughing up to keep her in office. But here's what the language that he chooses here is very powerful. Very powerful. Undersigned counsel derives no happiness when following the supplemental motion. This is not like I'm not sitting here clapping my hands in glee. However, let justice be done, though the heavens fall. Let justice be done, though the heavens fall. Actually, the heavens will not fall by unmasking biased and unethical members of the bar. Wow. Wow. I cannot tell you. This is a lawyer. This is a lawyer writing things you rarely will ever read in any filing by an established attorney ever again in your life. This last sentence here, not the poetry. See, what catches everyone's eye, the reason why you probably told me is check out footnote 3, is probably because you thought this is the cool language. However, let justice be done, though the heavens fall. And then, actually, the heavens will not fall by unmasking biased and unethical members of the bar. And Kimmy, you're right. This is powerful. But what's really shocking to me, you never, ever see a judge attacked by an attorney in labeling him in a court filing as being an unethical member of the bar. And look, maybe he's referring to Love and Hilton, which it's considered very aggressive to do that to an adversary. But for him to put in a filing that he's unmasking biased and unethical members of the bar, that can only be read as an attack directly on Judge Glanville. Because everyone knows The ADA is supposed to be biased against you. You call a judge biased and unethical in this direct way, and frankly, maybe he had to. The reason you don't do, you might describe the behavior as being unethical, grossly irresponsible, to the point of being prejudicial. This direct attack, where a lawyer is attacking a judge as being biased and unethical, is such a taboo line that litigators are taught to never ever cross that line. It's a third rail type of thing. Nobody writes a sentence. No litigator would ever write a sentence like that lightly. I'll tell you right now. And it's not the whole "let the heavens fall." That's not the part that's shocking to me. That is lawyers being lawyers. Good lawyering. Impressive lawyering. I'm not knocking it at all. I think it's very well written. But this language right here, unmasking biased and unethical members of the bar. This language, you don't see that. You don't see that. For good reason, because this is considered like basically stepping on the third rail. It's the sort of thing that you write something like that in papers, and more often than not, you're going to see your license get suspended. Because you're never supposed to accuse. It's considered very unprofessional. Now, given the context and nature and circumstances, I applaud his willingness to stick his head in the noose like that. Most lawyers would not write those words. Just wouldn't. It's so deeply ingrained in us. But I understand he's trying to make the point that this was biased. This was unethical. But most people would not say an unethical member of the bar. You just call unethical conduct. I'd be curious to hear some of the other litigators who I consult with on air with you guys, giving their thoughts about the ending of that sentence there, unmasking biased and unethical members of the bar. Because that is very aggressive in ways few attorneys would ever have the cojones to do. Anyway, so what do we have so far? What we have so far is there's money that's being donated back and forth between Krause and Glanville, and that's why they want both of them recused. Also, he wants to get rid of these two assistant district attorneys and have them be recused. Ultimately, he's going to look to have this case dismissed if and when he's successful. First step first, knock off the heads of the snake. After you knock off the heads of the snake, then you look to get this case tossed altogether. But if it's not tossed, you say, hey, I need to question them, and how can I question them? How can I do this? They stepped into this. They walked all over. They jumped right into that wet cement and started tracking it everywhere. So now they're important. Now they're critical to this case. Maybe. It was Ritterman and Davis that forced Judge to give in so he can make the writ move. Yeah, no, I understand. He was compelled by the Georgia Supreme Court. YSL thugs may go free because DA and bench misconduct. Oh, I think they will. Don't read that. I've thought about this case. There's a case with a completely different judge, not Judge Glanville, a completely different judge. She's, I think, a relatively low-level judge. Judge Glanville is like the senior trial court judge in the criminal court there. This case that Kelly is referencing is a different judge who went out clubbing and ended up assaulting an officer and got into a whole fight and saying, I'm a judge. And my friend, I'm a judge. She's a judge. What do you think you're doing? She a judge. And, clearly speaking in that French accent. And which is weird because they're from Atlanta. not New Orleans. So I've thought about covering that case. I've thought about covering it. I'm definitely not doing it tonight. Anyway, I want to get down into the allegations. To me, the interesting part is much less the first 30 pages, where he's basically just giving a very detailed review as to everything that happened. Much more interesting to me is the affidavit that they signed. And that's where we're going to jump to. That is exactly where we are going. Let me check out over here first. Pinochet's helicopter tours, let justice be done, though the heavens fall, quote, was famously said by New Orleans DA Jim Garrison after the trial of Clay Shaw. Look at you. Look at you. Look at you. So learned. So learned. All right. This is the affidavit. So what we were reading from before was basically the background, but this is facts that they're swearing to. So joint affidavit, Brian Steele and Keith Adams, Esquire. We are over the age of 18, suffer no legal disability, make this joint affidavit based upon our own personal knowledge, counsel for Jeffrey Williams in the above style case. This joint affidavit is timely filed on Monday, July 8th, 2024, which is 5 days from July 1. Now, a lot of you are saying, wait a second. There's more than 5 days between July 1st and July 8th. But they're saying business days. Business days. 5 days. We're not counting we ain't counting we're not counting no July 4th. We ain't counting no Saturday, no Sunday. Take all that stuff out. We're good. We're good. So, the date that Afghans first received a transcript of the ex parte communication that occurred in chambers of Judge Glanville dated June 10th. So we first got that on July 1. And we're kicking this out to you within 5 days of that. That's the key date. This information we're sharing with you was within the past 5 business days. Afghans hereby expressly adopt and embrace all statements made in the motion to disqualify, recuse Judge Glanville and the joint affidavit attached thereto, dated June 17th. Herein, and rely on that timely filing of certain motion to recuse, as well as the affidavit in toto herein. So this is basically a statement saying we're standing behind everything that was sworn to previously when we first filed this motion. Judge Glanville met with lawyer Love and Honorable Attorney Bumpus, lawyer Hilton, and at times the court reporter, sworn witness Mr. Kenneth Copeland, a.k.a. Little Woody, members of the District Attorney's Office, including but not limited to Fulton County District Attorney's Office investigators Long and Hamilton, as well as members of the Fulton Bar. His counsels, and this nice big fat meeting that everyone but us was invited to. And outside Mr. Williams and his counsel's presence, and discussed critical parts of Mr. Williams' case. And this was violation of Mr. Williams' constitutional rights to a fair tribunal, right to be present, right to due process, right to a fair trial, right to assist counsel, right to confront witnesses. See our United States Constitution, which apparently the judge and the district attorney's office seems to have completely forgotten altogether. So what are the different rights we got here? Let's see what we got here. Fair tribunal. This clearly was ridiculous because they're working together with the judge. Right to be present. Right to due process, right to a fair trial, right to assist counsel, right to confront. It's all there. It's all there. This is such a terrible move. Such a what the hell were you thinking? Move. The purpose of this ex parte meeting between Lawyer Love, Lawyer Hilton, and Judge Glanville was to act in unison. This is important. in order to influence sworn witness Mr. Copeland to testify against Mr. Williams. So they're trying to force his hand, force little Woody to come in there and say, that's the guy. That's the guy. There was absolutely no lawful purpose for this ex parte hearing to occur. To wit, there was no allegation by Mr. Copeland that he was somehow threatened. If he said he was threatened, then you can understand him coming to talk to the judge. Say, I don't want to come in here. I'm threatened. So there was no allegation by little Woody saying that he was threatened. No allegation, Mr. Copeland, that he was not satisfied with his counsel. He's like, I need a new lawyer. So that's why he's meeting with the judge. No allegation, Mr. Copeland, that he needed to meet with Judge James Glanville. He wasn't even asking to be there. He was dragged in there himself. This is pretty funny. Judge Glanville met with Honorable Attorney Bumpus, lawyer. That is pretty funny. That is pretty funny. That's what I should refer to myself. I should refer to myself as the Honorable Good Lawgic. The Honorable Good Lawgic. That's what I should be doing. The Honorable Good Lawgic. None of you ever referred to me as honorable before. You don't love me. You never loved me. Taken for granted here. The Honorable Attorney Bumpus. All right. Instead, this ex parte meeting was orchestrated by lawyer Love, Hilton, and Glanville. Why? Because they want to convince Copeland to testify against Williams. This influencing a witness meeting eviscerated any appearance of regularity of the tribunal and demonstrates. I mean, this is not a regular tribunal, regular courtroom activity. There's no regularity here. Demonstrates at the very least that Judge Glanville is biased for the prosecution and against Mr. Williams and his counsel. He's against us in a way that does not give any fairness over here. Love begins this unethical ex parte conference by explaining, and this is where they start going through the transcript. So what they're basically doing is, we read through the transcript, at least much of it. I don't know if we made it through all of it. We went through much of that transcript. And when we're going through it, you can see all the different ways that he's being threatened. I think we actually did make it all the way through. And what they're going to do now is take excerpts and say, this part right here, violation that way. This part here, violation that way. And that's what you do. This unethical ex parte conference by explaining that the state's reasons for Glanville to meet with the sworn witness Copeland is to impress upon Copeland. Why are they meeting? It's to impress upon Copeland that he needs to testify for the same reasons lawyer Love announced in open court on Friday. To wit, the Honorable Jonathan Melnick, Esquire, that Melnick was the other attorney for Copeland, for Little Woody, the witness, abandoned his client. That was her claim. At this point, rather than acting as a true judge, protecting our court system and its reputation by questioning, why am I meeting ex parte and why am I being used to answer in front of only members of the state of Georgia questions of Mr. Copeland? Why don't we do this in open court? Judge Glanville, because he's biased, agreed to help convince Mr. Copeland to testify adverse to the liberty of Mr. Williams. Wow. Like I said, very aggressive language. Very aggressive. But there you go. Judge Glanville has asked for it. He displayed considerable bias here. Lawyer Love made untruthful statements about email correspondence with the Honorable Jonathan Melnick. See Exhibit 1. Attached here to emails with the Honorable Jonathan Melnick, the Honorable Maxwell Shart, Esquire, and Affy and Brian Steele. Lawyer Love continues to make false representations, and Judge Glanville knows, if he has paid attention at all during the proceedings, that Lawyer Love makes intentional misstatements of fact routinely. She a liar. She a liar. You know, if you've been following anything in this case, you know that Lawyer Love regularly, routinely lies.
You, sir, are a liar. Liar. Your pants are on fire.
Yet Lawyer Love deflects her misconduct and cites the ethical rules of conduct for attorneys during this ex parte hearing. Lawyer Love explains the need for the ex parte communication. All that aside, we would like an opportunity for the court to address Mr. Copeland, with Mr. Copeland's stand-in counsel present. Does it really? That has an echo? That sucks. I wonder if that's because... I think I know how to fix that, but that's going to be a nuisance. Oh, oh, his my comments about his dude's ripped. He's ripped. I miss this. Hosts, once my play button reaches, you can forward it to me as a gift to avoid charges. Keep up the great work from your leader. I'm all over that. I'm all over it. All right. We would like an opportunity to the court to. So she says they want an opportunity to the court to address Copeland and Mr. Copeland's stand-in counsel present to allow Bumpus an opportunity to explain to Mr. Copeland everything that Lawyer Love has just said. So we want Bumpus here to come in here, and you all should basically tell him how a whirlwind of crap is going to fall upon you, little Woody, if you don't get up there and testify. And we're going to spend the rest of your friggin' days in jail. Again, Judge Glanville has thrown away all appearance of propriety by permitting this ex parte meeting. You're not allowed to permit this meeting to occur at the behest of Lawyer Love and or Lawyer Hilton. Why? Why would you not have them there? If you're not doing anything illicit, why would you not have defense counsel there? It's kind of crazy. Like, why are you not doing this in front of the defense counsel? You might not look, if they're going to do this outside the presence of the jury, okay, sometimes you don't want the jury to hear this conversation, but everything they're saying here is up to snuff. Everything they're saying here is legitimate and ethical. Why would you not have this conversation in front of defense counsel? And why is Judge Glanville agreeing to this meeting in the first place? By permitting this ex parte meeting to occur at the behest of the ADA Love and or Lawyer Hilton, Glanville is not independent and is being led by the nose by members of Fulton County DA's office. That's putting it kindly. This is because Judge Glanville is a member of the prosecution team. Wow. Wow. Very, very aggressively worded. Very aggressively worded. Glanville then adopts the wrong law offered by Lawyer Love that Mr. Copeland will be held in custody until he testifies. Lawyer Love seems to somehow assert that Copeland can be kept in custody even after Mr. Williams' jury is discharged. We can still keep you here. Judges are presumed to know, respect, and comply with the law. In re Judicial Qualifications Commission formal advisory opinion. Objectively, Judge Glanville permits several misstatements of the law in order to have Mr. Copeland testify against Mr. Williams in order to assist the prosecution. So she's getting up there, making up crap law as she goes along, and Judge sitting there, yep, that's what's going to happen. That's what's going to happen. It is crazy. It's outrageous. And that you can understand why they're saying he's part of the prosecution. He's actually, in a certain way, the most effective part because he's the one who's most convincing, right? You don't expect a judge to basically be misstating the law to you. He's not, and he's saying, I'm going to uphold it. Let's see, that's a clear implication to any witness who's sitting there. That's what little Woody's going to think. Glanville becomes an advocate for Mr. Copeland to testify against Mr. Williams by telling Attorney Bumpus how to communicate with her client. Mr. Copeland specifically Mr. Copeland, specifically that Mr. Copeland is going to face some pretty significant cross-examination. And Glanville explains to Attorney Bumpus that it's all in the message and the packaging in terms of, I think Mr. Copeland is, a savvy person, but, he's certainly going to be subject to thorough and sifting cross-examination. Why are you talking to her about this? What is happening here? The fact that Glanville is dispensing legal advice and strategies to Attorney Bumpus, guiding her on how to speak with Copeland in order to have her client testify against Mr. Williams, is a clear, direct fact that Judge Glanville has forfeited his judicial role. And he has! He has! Why? What is... That's not the place of a judge to sit here. This is what you should be telling your client. What? Citing In-Rate Judicial Qualifications Commission Formal Advisory Opinion, number 241. Judge Glanville is biased against Mr. Williams and is partial to the prosecution of Mr. Williams. This is fire. This is fire. Glanville, along with lawyer Love, continues to advise Attorney Bumpus what to tell her client. For instance, see here, they're coming with the quotes. This is coming from the quotes directly from the transcript that they attached the transcript as part of this affidavit. Part of Mr. Copeland's challenge, Bumpus, may be that you need to ensure, look, I'm going to be here. And if you think that they're going to ask you questions, they being the state or defense is asking a question that's going to bring out other crimes that you're going to be able to look to you and say, can I have a chance to talk with you? That's a quote from the judge. So he's like, don't worry, you can reassure him that he'll be okay because you're going to protect him. Love, who's working in lockstep with Judge Glanville, states, that's exactly right. It was weird. When we were reading through that transcript, I was like, this is so weird. Sometimes Love would be talking and Judge Glanville would be like, that's exactly right. It was like good cop, bad cop half time, but it was just like, it was instead of good cop, bad cop, it was just, it was bad district attorney and worst district attorney. Unfortunately, the worst one was wearing black robes. Love then inaccurately bashes Attorney Melnick by saying there's been an assertion that people are representing his interests. The biggest concern is Mr. Copeland's best interest, and they are just not here. There's absolutely no reason Glanville and lawyer Love are discussing what Attorney Bumpus should be telling her client. That's weird. I've never had a judge tell me what I should tell my client. And no reason for Glanville to permit lawyer Love to ridicule Attorney Melnick. Lawyer Love again misrepresents by claiming that the Honorable Attorney Melnick has been talking to Brian Steele and Max Shart. That's it. He's not talking to... saying that Melnick has been talking to Brian Steele and Max Shart. That's it. He's not talking to us. Why does Judge Glanville hold this ex parte conference and permit Love to falsely accuse me, Brian Steele, and Max Shart of obstruction and ethical violations by influencing a lawyer-client relationship? This is extrajudicial information that Judge Glanville should have never received. Even if it's true. Even if it's true, it's not his place to be hearing this. They're going through this, ripping this transcript line by line, line by line, line by line. Glanville continued to be prosecutor, Mr. Williams, when he instructs Attorney Bumpus that sworn witness Copeland can invoke the Fifth Amendment if he testifies about unrelated crime. Glanville tells Attorney Bumpus that sworn witness Copeland is, quote, probably thinking about, there's a lot of stuff the defense could ask me about that it's not known to a lot of people. And little Woody, he could also invoke the Fifth Amendment if it was some other particular crime. During this advice on what to explain to Copeland, lawyer Love and Judge Glanville are speaking with one voice. They just keep, one starts a sentence and the other one, like, are they making kissy faces? Because court reporters don't take down when there are kissy faces. You wouldn't know it. They're just taking down words. But if there's a whole in between, we wouldn't know. That would not be reflected in the transcript. I'm not saying that there were kissy faces between Judge Glanville and and the assistant district attorney. I don't know. I was not there. I'm simply saying you don't know that there weren't. And if there had been, it would have probably appeared not too unusual, given the nature of the way the conversation was flowing. Not saying that there were. I wasn't there. But if they were, we wouldn't see it in the transcripts. I got to get Kayla Bumpus on here so she could talk to me. Tell me. I'll be like, were there kissy faces? Were they kissing? Were they like sort of like blowing kisses in between? Making goo-goo eyes at each other, Judge Glanville and ADA Hilton. During this advice on what to explain to Mr. Copeland, Lawyer Love and Judge Glanville are speaking with one voice. This has Judge Glanville presuming and pontificating that Copeland is involved in a lot of unrelated crimes that Mr. Williams, a criminal himself, is aware of same. Thereafter, Glanville and Love jointly explained to Bumpus that Melnick injected himself into these proceedings. The fact that Judge Glanville is having these conversations in the first place, then agreeing with and then championing the prosecution's case, mandates even to a casual observer that Judge Glanville is biased against Mr. Williams and favors the prosecution. And he's going to keep on this theme over and over again because it's one example after another. One example after another. There's no way this judge stays on this case. There's zero chance. Zero chance he survives this motion to recuse. I'll tell you right now, he has serious issues with his job security. Serious issues. Because it's shocking to imagine such a thing going on. This is such a blatant abuse of his discretion and authority as a judge, as a member of the bench. Like, how does he keep his title here? This great bias cannot be more clear when Judge Glanville explains to Bumpus that she needs to give sworn witness Copeland the questions that the state is going to ask him when he testifies, and ask Mr. Copeland to tell Attorney Bumpus any other facts that they, meaning Mr. Williams and his co-indictees, might ask about. What? So Bumpus is supposed to go to Little Woody. She needs to give him the questions that the state is going to ask him when he testifies, and ask Lil Woody to tell Attorney Bumpus any other facts that they, and she should also tell her client, tell me any other facts that the defendants might ask about. Further, as long as Bumpus has knowledge of other crimes that sworn witness Copeland has committed, Glanville states that Mr. Copeland will be fine because the state's only going to get into questions that was provided to Mr. Copeland. It is ridiculous to claim that Glanville is not biased and is impartial. Glanville continues explaining to Bumpus that the reason she needs to know from Mr. Copeland what crimes he has committed in the past is the defendants know more about Kenneth Copeland than anyone else, so they are probably going to So he's now telling her how to do her job. You need to go to your client. You need to tell him, fess up to me about all your crimes. So this way I'll know what questions are going to be asked to you. What the hell? What the hell? What gives Glanville the right to state that Mr. Williams knows more about Copeland's supposed bad conduct than anyone else? That is very weird, unless he's assuming that he's guilty. In reality, Williams hardly knows Mr. Copeland. Glanville has pronounced guilt onto Mr. Williams. There you go. Glanville imparts legal direction to Attorney Bumpus on how to prepare Mr. Copeland for cross-examination and how to prepare Attorney Bumpus to object on behalf of Mr. Copeland. Glanville has tarnished this trial forever. Forever. As Williams can never have a fair trial with the way Glanville has acted, both in front of the jury and outside of everyone's presence, in ex parte proceedings with Fulton County District Attorney and witnesses. It's ruined. It's ruined. You pissed in the punch bowl. You didn't just piss in it. It's like you were importing foreign piss and like taking like a gallon and just sort of sloshing it all over. You went over to the wine bottles, popped those bottles open and started pouring it in there. Just started pouring it all around. Because this is just craziness what was happening here. Oh yeah, Mr. Williams, he knows more about Copeland's about Lil Woody's crimes than anyone. How do you know that? What makes you even say that? The conduct of Glanville, Love, and Hilton has caused them to be necessary witnesses at trial. Uh-oh. Uh-oh. That is going to be humiliating. Affiant intends to call as witnesses and cross-examine Judge Glanville, Lawyer Hilton, Lawyer Love on how many other ex-parte meetings the three of them, any other member of the prosecution team have had. Judge Glanville cannot be judge and witness in the same proceeding. I don't know what's happening here. That would be great. That'd be awesome. So that'd be great. Why do we need to call him as witness? Because we need to call him as witness and cross-examine Judge Glanville, Lawyer Hilton, Lawyer Love, and how many other ex-parte meetings the three of them and any other member of the prosecution team have had. Oh, this is one we found out about. We don't know about any other ex-parte. Maybe you're sitting there having your little parties back there in his chambers all the time. Maybe this is something you had like dozens of these. This is the one we know about. The only reason we got this is because Caleb Bumpus came out and taught us. How often are you meeting with the assistant district attorney? Glanville cannot be judge and witness in the same proceeding. Love and Glanville, acting in concert, tell Bumpus that Mr. Copeland can cancel legal representation because Lawyer Love, Lawyer Hilton, and Judge Glanville have done everything to clear Copeland of judicial exposure, which we argue probably haven't. Without any reason to believe that Copeland might be fearful for his personal safety, Glanville injects the safety concern as a hypothetical reason that Mr. Copeland would not testify. In other words, when he's sitting here assuming maybe you don't want to testify because you're worried that the defendant's going to kill you. They're going to kill you. Maybe you're worried about that. Maybe you're worried about that. But don't worry about that. And the defense counsel is like, why are you assuming my client would do something like that? Like, where do you come off like with that assumption? He never expressed a concern like that. You're just injecting that and projecting your thoughts about my client onto what he's thinking. There is no evidence of saying. Glanville tells Attorney Bumpus that Mr. Copeland has to give testimony, though. I mean, that's what he has to do. Always got to give the testimony, whatever it is, good, bad, or indifferent. The question must be asked, why does Mr. Copeland have to give testimony? Is it because it favors the prosecution? Whose vantage point does Glanville view this trial, good, bad, or indifferent? To whose position? Judge Glanville must be recused. Meaning, what does that mean, good, bad, or indifferent? What's their good, bad, or indifferent? To whom? Meaning, what the point that Steele is asking here is, okay, tomorrow I'm going to be covering the Baldwin trial, which you should be joining me for. For one reason or another, I really don't care whether he walks or gets convicted. So to me, I'm not going to see testimony as being good or being bad because I'm not rooting for one side. I don't care. I really don't care. I don't like him. I don't like the state. I don't like either of them. So I'm not going to see someone be like, "Oh man, good day." I mean, if I see good lawyering, I'll remark on that. But that's not what you're talking about. We're talking about, the testimony is good, bad, or indifferent. Court report announced off the record. Mr. Williams tends to call at trial Lawyer Love, Judge Glanville, to determine what was discussed during this off-the-record time period. Glanville has the audacity to bring sworn witness Copeland into his chambers without the request of Attorney Bumpus, but the request of Lawyer Love. So the district attorney says, I want you to bring the witness in here. Glanville says, let it be done, etc., etc., etc. Bring on the witness. Assistant District Attorney has made a request that I shall grant. I'm his lawyer. No, bring on the witness. Bring me grapes. From 9:34 until 10:03 a.m., nothing is recorded by the court reporter. So we don't even know what the hell happened there. No one knows what the hell happened during that time. It takes a long time to bring the witness in there. Affidavit will call Lawyer Love, Lawyer Hilton, and Judge Glanville to probe what occurred during this time period. So I need to get them in here. This is why they can't have to be recused. Now, here's the point that the reason why he's bringing this up, in case you're wondering, as far as that he's going to call him as a witness. Once he's saying, if he can establish to the court's satisfaction that he has a legitimate right to call certain person as a witness, so they now become an expected witness, they cannot serve another function in the case. So it's another way of attacking Glanville's status as judge. One is he's biased, have to be it, or he gives the appearance of a lack of appearance of partiality. So that's a reason to have him removed. Conflict of interest. If he's serving in a dual role because he now becomes a necessary witness, he can't serve in that function any longer as judge because he's now a witness in the case. Same goes for the assistant district attorneys. So he's trying to convince the court that Steele is trying to convince the court that they have now become necessary witnesses. Because even if they don't find, which I'm sure they will, even if they don't find that there's been sufficient wrongdoing by Glanville and or the district attorney that they have to be removed from the case, and that they still would be okay to be on the case, the fact that we need to conduct a direct examination of him on the stand now creates a situation that he cannot serve both role as judge and witness. So our right to call him as a witness means you have to cross him out from the role of being judge. That's why they keep going down this road here. Once in custody, represented by counsel, sworn witness Copeland is brought involuntarily into Glanville's chambers, and Glanville explains, I just wanted to bring you over and let you talk with Bumpus and see if there's anything that you need to ask the counsel or Miss Hilton of the state of the court before we bring to you this morning. Because we would like to hear your testimony, and it's kind of where we are at in this point in time. Who's we, Kemosabe? Who is we? What do you mean we? Why do you care? Why do you care if he's going to testify? Oh, we really want to hear your testimony. Why? Why do you care? Let's say he says, I'm not. Why do you care? How is that your business? He's right. He's right. He's telling me, maybe you want to ask questions to the state. Why would he be talking to the state? I need to ask questions of you. What? Like he's trying to facilitate to get this guy to testify. It's not the court's interest to get someone to testify. That's not their role. That's not their duty. That's not their function. And the only person whose function that would be a member of the state. This is him working in cahoots with the state. Is he going to start talking to witnesses for the defense and say, you got to testify here also? What the hell is going on here? It's hard to articulate how wrong this ex parte summit is and how obvious it is that Glanville discarded the sanctity of the judiciary to become part of the prosecution team. Glanville is biased, and this case is constitutionally broken. Broken, I say, because of the conduct of Lawyer Love, Lawyer Hilton, and another member of the team, Judge Glanville, another member of their team. He is. Why is Glanville inviting Copeland, a representative party, to ask questions of a Lawyer Hilton or other members of the DA's office or Fulton County or the court? This is beyond comprehension. Because Judge Glanville is not acting as an impartial seasoned jurist, but as part of the prosecution team and must be recused. Get him out of here. Get him out of here. I don't want to see this guy. Lawyer Hilton makes it clear that Mr. Copeland has never stated that he has safety concerns, which is stopping him from testifying. Hence, the whole safety concern discussed earlier was totally fabricated by Judge Glanville and Lawyer Love. Hoisted on your own petard. She's because in the early meeting, she's like, you haven't said anything about being scared. Well, if he didn't say anything about being scared, why is he in here? Why would you bring him in here? Why is Judge Glanville saying, if it's a safety concern, don't worry, don't worry? Joe, please recommend the most effective route to battle Ron Whiting, trying to get a special counsel to investigate Clarence Thomas. I think Clarence Thomas is okay. I'm not worried about him. Thank you for the membership. New member of the following. Who'd you bring in here? Who'd you get? Was it a good one? Did you get a good one? Ooh, Ward RO8E. Gifted membership by Spuds. Please, Ward. Oh, you see, he already said thanks, Spuds. Look at that. Look at that. He already said, I didn't say anything. He just says thanks. Well done, Spuds. That dude been here a year. He got like the whole Humvee thing going on there. I really need new icons. Copeland states, I never been truth a day in my life till I just made this statement right now. Which is one of the great things. This is a quintessential Brady versus Maryland evidence. Judge Glanville never uttered a word, nor did Lawyer Hilton or any member of the Fulton County District Attorney Office provide defense notice to this Brady evidence. Why don't we get that? An admission that he's always lying? Same is unconscionable. Affy intends to call Glanville as a witness at trial, as well as Lawyer Hilton discussed the failure to reveal this information to me and for the jurors to be able to understand. The jury has a right to know that when a judge reads the instruction that the court has no interest in this case except for a fair trial, same is not truthful, as Glanville is on the prosecution team. You cannot get more aggressive than Steele is. I am giving him mad props. You couldn't word this any more aggressively. Glanville, Hilton, Love will be called as witnesses and have been added to Mr. Williams' witness list as announced by affiant in open court. The fact that these three persons attempted to hide Brady evidence is beyond the pale. Glanville instructed the jury that he has no interest in the case except to see a fair trial. And that's the one thing that he hasn't given them. Same is untruthful. See? And the jurors need to hear from these three witnesses in order to make a determination on whether same was truthful or not. So we don't think he's here to give us a fair trial. That's not why we're here. We're not here for a fair trial. He doesn't care about fair trial. It's the last thing he cares about. Hilton gives inaccurate legal information on whether Copeland can be prosecuted at all. Gives some far-fetched ideas about federal statute of limitations and the state of Georgia statute of limitations. She's like totally making crap up. And we were talking about this. Like, how does she know what the statute of limitations are? Glanville sits idly by, allows Lawyer Hilton to misrepresent to a sworn witness Copeland that he cannot be prosecuted for crimes, which is just not true. Anyone with modest interest in the case would know that the prosecution has called Mr. Copeland an unindicted co-conspirator and that the supposed RICO conspiracy statute of limitations continues today. Today! Thus, Copeland could be prosecuted both in federal court and in the state of Georgia for crimes. This is wholly contrary to what Lawyer Hilton and Glanville allowed Copeland to believe. Basically walking him into self-incriminating himself. And then pretending that they could not be incriminating. Moreover, Hilton and Glanville do not disclose other Brady material, Brady evidence, as lawyer Hilton explains that the state can assist Copeland with finding different places to live. We need to know if you're offering him, you're going to give him some luxurious condo to move to. This is part of an agreement that should be revealed pursuant to Giglio versus United States, 405 U.S. 150. But they never told us. Hilton's a witness at trial and will be cross-examined. We are going to question her. Why didn't you give us this Brady information? Same goes for Judge Glanville. Hilton then tells little Woody, who at the time was a representative person, that he can speak with her without Bumpus present. Glanville, which that's crap. You don't need to have her here. Come talk to me. Let's have private conversations. Glanville did nothing to stop this potential unethical conduct. He's sitting there. He's like, sure, why not? We're so deep past worrying about the Constitution. Why start now? Why start now? We're totally fine. I'm totally fine just letting all this crap slide. Hilton again tells Woody that he's immunized from prosecution while Glanville sits silent. Statement is not true. Copeland received only use immunity. Attaching it to the order of use immunity. However, Glanville reinforces lawyer Hilton's wrong information because Glanville is part of the prosecution team. Instead, what does Glanville do? He's like, oh, you're not going to be prosecuted. Not that it's his call whether or not they're prosecuted, but he's basically even promised. Glanville and lawyer Hilton are acting as one, not separate as required by law. Glanville goes on and tells Copeland that he is worried about what the defendants may ask you because they may know your business. You can't be prosecuted for any of those. First, that is not true. Copeland was only given use immunity to affiant's knowledge. However, it's clear that Glanville is an assistant to prosecution because, and as part of prosecution, he needs Copeland to testify because he's not sitting here as a judge. He's part of the prosecution team. Importantly, Glanville again asserts that Williams and other co-indictees may know your business, but if they ask you about things you might think you might have some liability with, you can't be prosecuted for any of those. This presumes that Mr. Williams knows Mr. Copeland's criminal endeavors, because Williams is a co-conspirator with Mr. Copeland. Glanville is far from acting as an impartial judge. Copeland again puts an end to any made-up safety concerns and explained that he does not want to testify because he will set a bad example for his family based on his past misdeeds. See, he didn't say anything about safety. He's sitting there in what he probably assumes is private chambers. He doesn't say. A lot of witnesses in that circumstance, if they were worried about their safety, they'd be like, you can't protect me. I'm not okay with this. Right? That's what you think they'd be saying. He didn't say that. He's like, I don't want to be a bad example of my family. One must ask, why is this ex parte conference occurring and why does it continue? The only logical answer is that Glanville, Love, Hilton, they're all sitting here acting in concert. And they've got one agenda: to ensure that he testifies against Williams. That's exactly what you call biased judge. Unethical prosecutors. Constitutionally broken case. Hilton never provided the Brady material that Copeland had told her in the past that he was a liar. Glanville sits mute. Does not ask whether the Brady evidence was provided to affiant. Did you tell the defense this? They said that? No. He doesn't bother inquiring about that. Why? Because he's part of the prosecution team. Copeland explained that he had never told Hilton that the Honorable Attorney Melnick was not a lawyer, and thus lawyer Hilton met with represented party. He never told Hilton that Melnick was not his lawyer, and thus Hilton met with the represented party. Judge Glanville does nothing to discuss potential ethical misconduct by lawyer Hilton, lawyer Love, and other members of the DA. Lawyer Hilton told Mr. Copeland that he would be held in custody until every last defendant had been tried. Not just the 6 on trial, other ones too. Glanville sits mute, delegates his judicial discretion of punishment and says, yeah, you cover it as to like what kind of punishment he's allowed to get. You sit here. I'm spending time as the prosecution. You can spend time playing judge. Why not? Why not? No one knows about this. Ha, we're having a great time here in back chambers. Glanville, like lawyer Hilton, attempts to intimidate Copeland, telling him if he doesn't testify, then you're going to be held until all 12 co-indictee cases come to an end. This is just crap. Not true. Glanville is not even the judge on the other co-indictees cases, the same as being presided over by Judge Dempsey. Again, Glanville, Hilton, failed to reveal to me, Brian Steele, that he said, I told the police whatever different story I could think of to try and finesse my way out of the situation. Instead of turning this evidence over, Hilton and Glanville explained to little Woody he can simply testify, I don't recall, which is crazy. Glanville and Hilton are inseparable and biased against Williams. Glanville advocates for the DA's office of Fulton County. When he tells Copeland, just tell the truth, just get up there and testify, just tell the truth. At the same time as the DA saying, just tell the truth. They're all sitting there, tell the truth. Like they're like, what the hell is happening here? Let lawyer Hilton worry about the impeachment, and Mr. Copeland will not get in trouble. This excuses Copeland from giving false statements to law enforcement officers with the statute of limitations tolling provision. However, Glanville tells Woody, don't worry about it. It's criminal violations. You're not going to get in trouble. Seemingly, this trio spoke off the record, as Glanville recounts that as Miss Love said this morning. Remember, Miss Love said if you overtly lie about something, like if you told bold-faced whopper, then they can indict you on that particular charge. I mean, that particular false statement. So Glanville and Love are going to be called as witnesses. I need to call them as witnesses. And I need to have direct examination in front of this jury about your discussions off the record. Because what are you talking about? You made reference to conversation off the record. What the hell? How do we know what they said off the record? And to me, this is actually a great point here. Here is a reference made on the record to conversations off the record that clearly involved the judge, little Woody, the DA, and I don't know what they are. I need to question them about it. What did you talk to him about? So that he's a necessary witness. Maybe there's more Brady material there. This judge is in so much trouble. Oh my God, he's in so much trouble. He's now I'll tell you right now. To me, that makes him a necessary witness. He's a necessary. If this case moves forward, I was speculating that the DA is going to drop this whole case, and that still may happen. Some of you are saying no. If they don't, this judge is in trouble. Can you imagine him taking the stand? Can you imagine him being drilled on direct by Brian Steele? Oh my God, what theater! Wow. I gotta put all these people on the stand. That's why they gotta be recused, removed, and disqualified from his position of judge, as he voluntarily, knowingly, intelligently forfeited same. And I'll tell you right now, in this context, this sentence means judge from this case. But he actually means this in a much broader sentiment. That Glanville has to be recused, removed, disqualified from his position of judge, a high position of judge. This guy can't be a judge. Let's face it. This guy cannot be a judge anymore. He can't. I mean, he's going so far as to sanctioning lies that as long as it's not a bold-faced whopper, as long as it's not a whopper, just a serious lie, but not like something that's not believable. If you want to lie, go for it. This is what he's allowing to happen in his courtroom. I'm telling you now, his career is over. His career is over. And should be. This right here. Go ahead, come into my courtroom, get up on the stand and lie. Just don't make it something that's unbelievable. And that's totally fine. How can he sit as a judge in any case, in any capacity? This guy's not equipped to be a judge in a parking ticket situation. He's not equipped to be judge on a TV show where he's like Judge Ural, Judge Ural. This guy's not equipped to be judge in a beauty contest. Okay? He's not. You say get up in my courtroom, take an oath to tell the truth, and lie as much as you want, just don't make it sound crazy? How the hell can he ever sit on another case ever again? Ever. He's like he's totally fine with suborning perjury. Encouraging a witness, telling him, you must take the stand, feel free to lie. Wow. Go ahead. Lie as much as you want. Just don't make it sound crazy. Make it sound believable. No whoppers. This is just an astonishing. This is a death blow to Judge Glanville's career. This right here. You want to excuse the improprieties and say, okay, that's just tainted this case, and theoretically should end up with these defendants walking. Okay. Every judge has a bad day. Everyone makes mistakes. This is not a mistake. This is willful decision to basically push fiction out as fact in his own friggin' courtroom. There's no getting up from this. There's no getting up from this. Am I wrong? Am I overstating this? How on earth can he ever be trusted to sit and preside over a courtroom ever again? Walk me through it, because I can't understand how he can. Like I said, everything about having this meeting, an ex parte hearing, everything he did afterwards with the whole thing, we went crazy and went loco, saying, how did you hear about this? I need to know you heard about this, and starting to file contempt. Now you know why. Because over here, this transcript right here, this is death. This is death for his career. How can any superior court, how can the Supreme Court of Georgia see that transcript and say, we're going to let him sit on the next case? Really? I mean, who could ever take anything seriously in his courtroom ever again? It's just utter corruption that he's fine with. Totally fine with. It's crazy. It does seem, it's not just, it's also without due process. It's like you're throwing him in jail for what? Yeah, well, it doesn't matter whether they elected him. It doesn't matter. Scroll in. Sorry, I was just checking out what my diggers are talking about, and I'm confused as all heck. Trigger, I don't know what you're talking about. I don't know what's happening. I know what's happening. I want it now, yesterday, and yet take your time, be slow, no one. What the hell? Sorry. Little Woody states, indirectly, that if he confesses while testifying to murder, there's no statute of limitations for murder, and he'll be prosecuted. And lawyer Hilton stated that he will not be charged. Glanville sits mute. This Brady Giglio evidence never made its way to affiant by the judge, by the DA, or all these other people who had ethical responsibility to tell us about it. This, again, is unforgivable. Moreover, when Mr. Copeland is speaking about murder, lawyer Hilton says that if she knows Copeland is lying, to wit, knowingly lying on a material matter under oath in a judicial proceeding, perjury, Copeland would not be prosecuted. Don't worry. We're not coming after you. Not be prosecuted for knowingly lying. That's totally fine with us for your false statement. That's something we need to know about. So we can tell everyone, hey, you know, he was promised by the district attorney that if he lies, it's totally cool. And he'll never face any prosecution. Oh, and that's right after he said that he always lies. I had the same question, Matt. I had the exact same question. At a certain point, who's going to prosecute him, though? Fannie Willis? I mean, I guess there could be some sort of internal investigation by the state. I don't know. Special prosecutor of the state? I don't know. Attorney General? I don't know. Brad Raffensperger. Is he still there? Copeland told Hilton that she knew that he was going to take the fifth prior to taking the stand. I took the stand, and you knew I was taking the fifth. And Hilton denied it. Glanville silent. Glanville assured Lil Woody that he would not get in trouble for testifying. His testimony would then be impeached. Why would he say this? This could be a false statement. This could be perjured testimony. Yet Glanville is promising Copeland that he's not going to get in trouble. Flat out lie. Which, by the way, even when you get immunity privilege, like Fifth Amendment, that's not a license to lie. It's so long as you tell the truth. When you get Fifth Amendment privilege in exchange for testimony, that's only provided you tell the truth, not if you lie. This is unbecoming a judge of the great state of Georgia. Glanville ruled in his star chamber that if the state wanted to impeach Mr. Copeland, the state could do the same, and Copeland would not get in trouble for that. Why is Glanville explaining and anticipating rules on what may happen in court? Yeah, that's weird. Glanville must be removed, disqualified from the bench of Mr. Williams' trial. See, the language is getting a little more aggressive. Disqualified from the bench, meaning altogether. No, I mean of Mr. Williams' trial. But he means this guy gots to go. Hilton explained that if Mr. Copeland commits perjury, it would be treated as an inconsistent statement. Don't worry. Just an inconsistent. Lots of witnesses make inconsistent statements. That too, that's a Brady Giglio evidence. See, they're doing such an effective job of just going like line by line through this transcript and just showing how horrible, how blatantly they were just ignoring the Constitution and all their duties and every judicial code of ethics imaginable. With him basically sitting here like I'm the black robe version of the district attorney's office. Terrible. And I'm totally fine with you lying, which neither side should be okay with. Theoretically, district attorney's office could be disbarred for intentionally suborning perjury. Should be. It's unbelievable. It's really unbelievable. Glanville sat silent as Hilton told Copeland that he spent enough time in prison for YSL. This is extrajudicial information to Judge Glanville that marks YSL as a criminal street gang, a material element of a count's indictment, including count 1 RICO. Meaning, she's not allowed to say this in front of the judge that there's and inform him of their priors. This marks that persons supposedly associated with YSL are guilty of criminality. This entire illegal and unethical ex parte conversation was during a critical stage of the proceedings for which Mr. Williams, as well as his counsel, had the constitutional right to be present. Hilton explained that Copeland to Copeland that no one here expects Copeland to remember every single detail. Why is Hilton able to speak for Judge Glanville, who's present but silent? Where she's saying no one here. It's the weirdest thing. It is because they are one. They're on the same team. Glanville has denied Williams a fair trial and violated his constitutional rights. Hilton and Glanville function as one cohesive engine as shown clearly by the following. Yeah, and I noted this also when we read through this, how it was like they were finishing each other's sentence. Mr. Copeland asked, "You can't give me house arrest?" Hilton answers, "No. You can go home by taking the stand and testifying. That's what you..." And then Glanville states, "and come back tomorrow." Glanville allows lawyer Hilton to be the judge by telling Copeland that he cannot have time to think about whether he's going to testify or not testify, and that he cannot be sentenced to house arrest but will remain in jail. This colloquy illustrates the fact that Hilton, Love, and Glanville are working together as one, because she's like saying, maybe the judge would say you can have house arrest. No. She's like, no, you can't. You can go home by taking the stand. Otherwise, you're not getting house arrest. Is that her call? Is that Hilton's call? That's Glanville's call. But she's sitting there saying, you can't get it. No, you won't. And starting a sentence for him to finish. Glanville has forfeited the right to be judged on Mr. Williams' case. He's biased. A fair judge does not have to keep a person who refuses to testify in jail. There are other punishments besides same, including a fine, house arrest, whatever else the judge deems appropriate. What legal right did Hilton have to pronounce punishment upon Copeland? Well, he's serving as the ADA, so she can serve as the judge. Someone in the room's got to be the judge. Glanville fights for the prosecution by stressing to Mr. Copeland, they want your testimony. That is all they want, whatever that may be. Glanville is an advocate for the state. Why does Glanville tell a witness that the state wants his testimony? That's all they want. Why does Judge Glanville care that the state wants witness testimony? This is not a concern of an unbiased judge. Hilton explains that Copeland will not be charged with perjury. Although that is outside the order of use immunity, that's what's provided to Steele by Judge Glanville. Still, we didn't get any of the Brady evidence that we were entitled to. Again, Brady evidence, those of you who are confused by the term, is an obligation to turn over potentially exculpatory evidence. The state must turn over evidence that it has in its possession that may be exculpatory for the defendants. So, statements, if they know that he's made these statements, they have to share that statement with the defense. When he says, "I always lie," stuff of that nature, all these different things that he shared during the course of his ex parte, they had to share this with them, but they didn't. Quite the contrary, Judge Glanville tried keeping it from them. Just mind-blowing. Hilton and Glanville misstate the law of perjury and giving promises of no prosecution. Again, that too is evidence we need to have. And is not revealed by Glanville or Hilton. In fact, was hidden. We got punished for even asking for it. Had to face jail time for us. Glanville and Hilton are necessary witnesses as Mr. Copeland confessed to them. I did these crimes, I'm telling you that. Obviously, Brady information. Coupled with his early statements by Copeland about murder, which does not have a statute of limitations, Copeland is telegraphing that he is responsible for the indicted offenses. This critical exculpatory evidence was not given to me, Brian Steele, by Hilton, Lawyer Love, or Judge Glanville. In fact, it was hidden. See, I didn't even read this part earlier. And there you go. It was hidden. Affian will call Judge Glanville, Hilton, and Lawyer Love as witnesses because the jury needs to see and hear how Glanville and Hilton and Lawyer cajoled perjured testimony. They cajoled. These three cajoled and hid Brady evidence, cajoled perjured testimony, forced out of him, twisted his arm into giving lying testimony under oath, and worked together to wrongly convict Mr. Williams. The instruction that the judge has no interest in this case is not true because that's part of what he's got to say. He said, I have no interest in this case. That's crap. You clearly do. Mr. Williams will invoke his constitutional right to present a defense and call all necessary witnesses, including these three cohorts, these three knuckleheads, these three clowns, and that's why Glanville has to be recused. In a separate motion, Hilton Lawyer must be disqualified from continuing his case for their misconduct. So we got Glanville as a necessary witness, also because he handed an unknown document to Mr. Copeland's attorney in Mr. Copeland's presence. Affian will cross-examine Glanville regarding why he would give his unknown document for Mr. Copeland. Jury needs to hear from Glanville so they can determine whether Williams has been given a fair trial by a detached, impartial jurist. Because we don't think they're going to think that this was a fair trial. Hilton has to be called because she, like Love, met with Bumpus and or Mr. Copeland for an unknown amount of time off the record. So we got to question her about that. I need to have direct testimony from Glanville. I got to get direct testimony from Hilton. I got to get direct testimony from Love. And they're spelling out item by item by item. This is why they have to be removed from their current roles, because they're going to be sitting in the witness stand. And my client has a right to have to forcing testimony out of them. So these three people working together attempted to have Mr. Copeland dress in civilian clothing to appear before a jury as a witness. Why does Glanville care how a state witness Mr. Copeland appears for the jury? This is specifically true since Glanville did not do the same with an earlier witness, specifically Mr. White, who testified in jail clothing. Glanville and Hilton speak for each other. Lawyer Hilton answered Mr. Copeland's question on whether he would be locked up for this. He's asking the judge, will I be locked up for this? And Hilton's the one answering. So long as you testify, we will get an order to get you released. Glanville remained dutifully silent. It's not your turn to talk. It's her turn to say what the law is. As she said, she/we would obtain an order to have Mr. Copeland released. Glanville and all of them, they're one and the same. There's just a little party here going on. And then again, they hand the lawyer and Hilton, they hand Bumpus documents that give Mr. Copeland unknown documents. And Affian will again examine. Whoa, what happened there? That was weird. What happened? So they're handing documents in front of them. We need to know about that. And the jury has a right to know whether Glanville has committed numerous ethical and unlawful violations. These are not the only times Glanville has shown bias. But, and let's remember that he, at first, when we asked the transcript, he said, "Hell, go to hell. I'm not giving that to you." He refused to release the transcript of this ex parte meeting. He claimed he was privileged. Glanville must be recused automatically since he defended his position against Mr. Williams' motion to recuse filed on June 17th. The Honorable Judge Krause must also be recused because as she sits on the Fulton County Superior Court bench alongside of Glanville and has accepted re-election campaign money from Judge Glanville, specifically receiving $2,000 in April 2024 while this trial is ongoing. She took money from him. This trial started January 4th, and she took money from him during this trial. And that's their affidavit. Now, I will share with you just a little legal perspective. An affidavit is a very, very important thing. It really is more important. And I talk about this many times. It's more important than his whole explanation stuff that's happening here. The reason it's more important is because an affidavit, when they swear to all these different facts, this now becomes evidence. All this stuff that we just read through for the last hour and a half, this is all evidence that the court can consider. And I know it looks like it's just another attorney statement. When they swear to these facts under oath while also lacing in their legal arguments, the facts that they're swearing to become evidence. Now, the knowledge of the facts, it's bolstered by the transcript and the supporting exhibits, including the transcript, that give legitimacy to their point. But swearing to something under oath is how you take out of court things and make it something that can be considered by the court. They do a phenomenal job. This guy, Brian Steele, is very impressive. So he swears to it, and Keith Adams swears to it, his co-counsel swears to it, and then they have attached the transcript from the ex parte hearing, which I'm not going to go through. But I think he's done a phenomenal job. And yeah, there's no way that Judge Glanville stays on this case. And I'll tell you right now, it's at least 50-50. He's tried his last case of his career. It's at least 50-50. Maybe he steps down, retires. I don't think he's ever going to sit another case in his life, nor should he ever. What a disgrace to the bench he is. Utter disgrace. Suborning perjury. Meeting with one ex parte meetings, sitting here twisting the arm of a witness, allowing the DA to basically harass and threaten and sit there nodding dumbly. Disaster. An utter disaster. Yeah, that's pretty funny. Did the transcript come out after the Woody Cross? The transcript came out on July 1st. The case has been suspended. They haven't had cross. The case is currently suspended while the court is mulling over this whole recusal motion. So, and I'll tell you right now, I don't think he's ever going to sit. I am going to go on record and say he's not sitting for another day on this trial. And I'll tell you right now, he might have spent his last day on the bench. And if so, thank God, because he's a disaster. He's an utter disaster. You know, Woody had said something in the cop interviews that the DA wanted in, but they knew they couldn't without Woody lying on the stand and giving the DA ability to impeach testimony through video recordings. Knew they couldn't without Woody lying on the stand. You don't call someone up with the expectation of impeaching them. It's a good question you're asking, Rhonda. It's a very unusual move to say, I'm going to call you to the witness and then impeach you. This is like 3D chess that I think is beyond these incompetent boobs. You're saying, get him up there because we want to get this testimony in. The only way to get testimony in is if I get you on the stand and I bring it in for purposes of impeaching. I don't think... this is you're talking like someone who's like, outmaneuvering, and frankly, I'm not sure if they actually know the definition of Brady. A Brady violation. So what I'm saying is, it's attributing such deeper skill to these DAs than they've displayed. So they seem like bumbling clods. So it's possible for someone to try to do something like that. I just don't think that's the case here. Glanville boning Fanny or one of Fanny's girls. One of Fanny's girls. I'm not going to speculate. I have no idea. I think he's a married man, from my recollection. But he's going to have a lot of time spent with his wife because I think his career is over. I really do. I think his career is over. And I cannot imagine he's going to spend another minute on this case in any sort of judicial capacity. Maybe he'll be a witness. That's possible. I think Fanny's going to end up pulling the plug on this case. That's what I'm expecting. Tomorrow at 10:30, Alec Baldwin trial. First opening statements. Right here. You'll see a link. You can watch it. You're not going to be able to watch it on X, but YouTube, Rumble, Locals, goodlogic.locals.com. It's going to be fire, this trial. It's going to be a lot of fun. We hang out with a whole bunch of attorneys. We're going to have a good time right here. Good Logic. Make sure you're here. It's the only place you ever want to be. Till then, my friends, I thank you all for joining me. I'm going to just do a little round the house thing. Make sure my housekeeping is all in good working order. So far, it looks so good. Yeah, I'm good. I'm going to land my plane relatively quickly because I am kind of tired. I need to get some sleep so I can get up and get to work. And I'm going to set that stream up right now. So thank you all for joining me. Don't eat some bugs. I will see you all tomorrow morning, 10:30 Eastern time. 10:30 Eastern time. 9:30 Central, 8:30 Mountain, 7:30. God, 7:30 West Coast Pacific. Catch you all then. Take care of yourselves as always. Don't eat some bugs. Good night and Godspeed.